Everybody, welcome back to another episode of Gossip About Prejudice. My name is John. Lindsay's name is Lindsay.
Hello.
Today, we'll be going over a really special case that's pretty near and dear to my heart. It's called U.S. v. Wong Kim Ark, and it is the foundations of birthright citizenship here in the United States. It's particularly relevant since the Trump administration is lining up a challenge to birthright citizenship that flies pretty much in the face of about 127 years of settled constitutional law. And so I wanted to come in, lay the foundation for the Wong Kim Ark case, talk a little bit about the history of the time when the case was settled and brought, like the political themes, and then end with the road ahead. The Supreme Court is going to be taking up oral arguments on Trump's case on May 15th, and there's currently a stay of further injunctions until there's a stay of injunctions until the Supreme Court can review the matter in substance. Lindsay, what do we know about birthright citizenship?
I personally know very, very little about birthright citizenship. I've lived in one single country in my life, so I don't know anything about how citizenship works. But I believe birthright citizenship means that, technically speaking, you have to have been born in a country in order to get any form of citizenship in that country. Is that right?
So that's correct, but it's not have to.
Oh.
It's if you are born here, you can get citizenship, but you can get citizenship other ways. But essentially, yes, like you can get it. I think in the United States, you can get it up to your grandparents. And I know this because when I worked for the federal government, I helped Italian citizens who had never been to America get their citizenship because their grandparents had American citizenship.
That's cool.
Very cool stuff. But those avenues are not under attack. We're talking about birthright citizenship, where if you are on U.S. soil when you have the child is a citizen, full stop.
So, okay.
Yeah, and we'll get into it in just a second.
Okay.
But first, I want to thank our sponsors. Thank you to Hemmat Law. We are here at Hemmat Studios. Whether you need a fantastic attorney or just want to join a fantastic legal team, go to hemmatlaw.com/GWP. Thank you to Quimby Bar Prep, our ever steady, rock steady Quimby Bar Prep.
Thank you so much.
And also big thanks to NordVPN for sponsoring the show. Let's jump right into it. So
Yeah.
I want to start by talking just briefly about why this is important. Birthright citizenship, because sponsorship of an American citizen, like if you have a citizen in your family, you are infinitely more likely to get U.S. citizenship.
Okay.
Who gets birthright basically defines a huge amount about who can come here and live here in the long run. It shapes entire communities, for better or for worse. It encourages people to move to the United States, which has been a historical halcyon of, New World countries, which is to say countries in the Americas, North, South, whatever part of Central. If you actually look at the map of birthright citizenship, it is striking. What is striking about this map is that it's all, largely speaking, either new colonized or New World countries. So like Pakistan was only recently created, so they have birthright citizenship. If you're born in Pakistan, you're a Pakistani citizen. But that's very unusual for the old world, across Europe, across Africa. Almost everywhere in the Americas, if you are born on soil, that soil is now your home. It is what we did it because the history is that, like, hey, we need people to move here. We wanted to make it easy to have people to participate in this system.
Yeah, new country.
Yeah, and so we are looking at, like, just letting everyone in by saying if you're born here, you're in the club, which is not the case in many places in Europe. If you're born in Europe, you're generally not a citizen.
Okay. So that the way that I'm thinking of where this would be most useful to get people to move to this country is, say, a parent, and their parents are pregnant, or they think they're going to have kids soon, and they move to this country specifically so that their kids can be born here.
Yep.
And then the parents then have an easier boon to then also become citizens.
Yep, exactly.
Beautiful.
And that's also why a lot of conservative talking points say they don't like this for that very reason.
Xenophobia.
Yeah, and I'm actually going to be talking about the Chinese Exclusion Act today in the lead up to the Wong Kim Ark case. It was back in the 1880s. So in the 1880s, early 1880s, the Chinese government at the time in the post-war civil era was slowly collapsing, basically. And China was in a sustained period of unrest leading up to and through a lot of the 20th century. The Communist Revolution started in 1927. Before that, it was technically ruled by the Imperial Chinese dynasty,
Okay.
which was in a sustained period of decline after what's called the Century of Humiliation with the Opium Wars and the
Oh,
British.
man,
and
that's a
basically,
name.
Yeah, various colonial powers were carving up mainland China because their central government was not powerful for a variety of reasons. And after the Communist Revolution started and the war against the nationalists led by Chiang Kai-shek, which is now the founding government of the Republic of China in Taiwan. So the nationalist government actually still exists.
I see.
Then in World War II, Japan invaded Manchuria. Basically from like the 1800s all the way through the 1950s and 60s, it was not being in China as a regular guy, not a good experience.
Okay.
With a history of colonialism behind them in the 1880s and 1850s, a lot of Chinese laborers emigrated trying to find a better life. In the 1850s, specifically when it came to the United States, a lot of Chinese workers migrated as laborers, first to work in the gold mines in the Yukon Gold Rush, but also to take agricultural jobs, factory work. Chinese immigrants actually built most of the Western Railroad.
You know, I think I heard that once before.
Yeah.
But they were pretty bad working conditions,
Oh,
right?
terrible.
Just terrible. Great.
Chinese laborers grew successful in the United States, and some became entrepreneurs. They settled into American, we're a melting pot. They settled into American society.
Love it.
But as the number of Chinese laborers increased, so did the strength of the xenophobia against them, because American workers viewed them as competition.
Sure.
Remember, in the 1970s, the United States was, I think, something like 27% employed in manufacturing.
Wow.
These days, it's only about 8 to 7%, depending on how you count. But even further back than the 1970s, it was even more here. Pretty much the only way you can make a living, generally speaking, was either in a factory or in agriculture or adjacent to those things.
No podcasts for them?
No podcasts. Yeah, they put huge tariffs on podcasting microphones in the 1880s, so no one had them.
Poor people.
And so Americans viewed labor as competition. And they were actually kind of right. Chinese laborers who came to the United States did so because they were desperate.
Yeah.
And they needed to send money, understandably, back to their families, in China to support them. Many of them could only send one or two people of their family to come work for higher wages. At the same time, the Chinese laborers often had to repay predatory loans to various Chinese merchants and businessmen who paid for their steamship passage across the Pacific.
What's that, like on the Mexico border, they call them coyotes?
Coyotes, yeah, pretty much.
Wow.
Because remember, there were no planes. You had to stay on a boat for about 6 weeks to make it across the trip.
Ooh, miserable.
And all these financial pressures came together and made it so that Chinese laborers had little choice but to work for basically whatever wage was offered to them.
Which then the American workers see as competition. They're just taking whatever jobs that they can.
Well, it's true. A lot of American laborers require a lot higher of a salary in order to sustain their U.S.-based families. I mean, it was cheaper back then, but relative to China, even less so. And also, American laborers, frankly speaking, had a lot more power to demand better working conditions.
That's for sure.
So the reason these Chinese laborers were so competitive for jobs is because they'd work for anything and they'd tolerate anything because they were desperate, which is a terrible situation to be in.
Absolutely.
And the complaints of the American worker were theoretically valid, but the reaction was very bad. Basically, everyone blamed the Chinese and in the immigrants rather than the businesses who were employing these people at subpar conditions. Like thousands, I mean, we don't even know how many, tens of thousands of Chinese laborers were injured or killed in the construction of the railway. The Western Railway, which at the time connected the two halves of the country, were not really connected because there were no commercial flights. And so you just got to have a wagon train or walk before the Civil War era. And so they massively expanded the infrastructure and conditions were brutal.
And that's a huge boon for the American
people. Yeah, it was basically just built on the back of desperate people.
Yeah. That's sad.
It was very sad, but what was even sadder was that they were blamed.
Yes,
when they were just looking for a better life. So, and there was a massive backlash against this huge, particularly in the west of the country, against these Chinese, quote unquote, invaders, is what they called them at the time.
Great.
And it wasn't just the feds, right? This wasn't just national. This was definitely local. For example, for about 20 years from the 1850s to 1870s, the California state government passed a series of measures specifically aimed at Chinese residents, ranging from requiring special licenses for Chinese businesses and workers to outright preventing naturalization proceedings.
Not cool.
But anti-Chinese discrimination at the local level actually violated an 1868 Burlingame Seward Treaty with the Imperial Chinese government.
Whoa,
So the federal government actually stepped in to stop a lot of these local measures to nullify them.
Oh, well, that's good. I'm
Most
glad
of
to
the
hear
time.
that.
Still very racist, but
Yeah, geez.
the tensions remained. And it culminated ultimately in the Chinese Exclusion Act of 1882. Absolute banger of a title, straight up there with the Fugitive Slave Act of like the 1860s or 1840s or whatever it was. Real great work by Congress on that name.
Wow.
Congratulations, Fugitive Slave Act. You've got competition in the Chinese Exclusion Act of 1882.
Seriously?
The Fugitive Slave Act, for a little bit of context, it was the act that allowed southern states to basically extradite slaves that had escaped to the north. That's a whole other episode right there. It was the Chinese Exclusion Act was a federal law that basically banned all Chinese immigration. It was also historic in that at this time, it's weird to think about, there were no immigration laws.
Like none.
You could just show up.
Oh,
Generally speaking, you can just come into the country. You could just show up.
that's interesting.
And so this started what we consider normal immigration practices, which is to say, when you hear of people emigrating to the United States and just walking off the boat on Staten Island in New York, that's how it worked.
Wow.
You just like showed up and you
So-
could just get there.
So easy, so much cheaper.
Yeah, it was the Chinese Exclusion Act was the first major law to restrict immigration based on national origin and race into the United States. It effectively banned all Chinese laborers from entering the country, and it also denied current residents the right to become U.S. citizens.
Oh, that's not cool.
Yeah, so it just
Wow.
banned citizenship. Well, it banned
Wow.
it banned future citizenship.
Mm.
So if you somehow already had U.S. citizenship,
You're-
safe.
You're good.
Yeah,
But
it was not retroactive. So they didn't try and strip citizenship from existing people. But
good.
most of these laborers did not have citizenship. So
Yeah.
it effectively banned all Chinese immigration, specifically Chinese. It was racial. I want to make that
Jeez.
clear. It was
It
not
was
like,
racially motivated.
yeah, well, I mean, even today, 97% of mainland China is Han Chinese ethnically. So, like, even if you said we're just banning everyone from China, that's basically also effectively a racial ban.
I see.
Anyways, but that's semantics. They weren't thinking that far ahead in 1882.
Gross.
Highlights of the Chinese Exclusion Act is requires non-laborers the few non-laborers who sought entry into the United States, like diplomatic officers from the Chinese imperial government, to obtain certifications from the Chinese government that they were qualified to emigrate and be in the United States. Problem: immigration and customs officials made it increasingly hard over time for people to get their documents. Like they upped the standard over time to basically try and stop all Chinese people, even diplomats, from getting into the country. And at the same time, the Chinese imperial government was eroding. It was like a time of extreme instability. So between those two, even like imperial officials couldn't really get into the U.S.
These folks just need to make money and feed their
Yes.
families.
And the Chinese who were already in the country, if they left the United States, they had to obtain like pretty much a visa to re-enter. It was called a certificate, but still. Congress, moreover, refused state and federal courts the right to grant citizenship to Chinese resident aliens, although the courts could still deport them.
Huh. Is that something that state and federal courts can do now? Grant citizenship to?
Only federal.
Okay.
Basically, I think what they did was that like all the sources were a lot of details, but I think what they did is they basically just said, stop hearing these proceedings.
Okay.
The federal government has always maintained purview over citizenship and immigration for good reason. We don't want like Washington having different rules than California and Oregon. When the Exclusion Act expired in 1892, because it was initially only like a 10-year period, Congress extended it for another 10 years in the form of the Geary Act. It was basically just an extension of the Chinese Exclusion Act, and it was made permanent in 1902. So it was basically Chinese Exclusion Act made it into the 20th century.
Oh.
And it was only repealed in 1943 to appease communist China as a wartime ally and bolster their morale in the fight against Imperial Japan.
1943?
Yep. Yeah.
That's way too long.
Even then, quota limits remain. So like they repealed the act as a, like symbolically, but then quotas remain that still limited the amount of immigration. Guess how many like visas were handed out to Chinese immigrants every yearly on a yearly basis after 1943?
After 1943? I mean, I'm thinking like a couple thousand.
Logging in that answer?
Sure. Locking it in.
105.
Really?
105 Chinese immigrants permitted per year on an ongoing basis through the 1940s. It was later amended, but
minuscule.
Yep. So it basically was repealed just symbolically.
Wow, that's gross.
Yeah.
That's really gross.
But to be fair, it was not as a response to like opening their borders and like peace among men. It was just as a political move to appease the communist government in their fight, because we use the Chinese government as basically a meat shield against Imperial Japan, because they were fighting a land war in Manchuria while we were invading by sea. My grandpa was one of them.
Hey, gotta love a history lesson.
So basically, the Americans never learned their lesson. It was never about fairness or justice. They just repealed it because they felt they had to keep the Chinese fighting. The reason this matters, the CEA represents a seismic shift in policy. It was a time when anyone from any country could come in and basically just reap the benefits of American society and get citizenship relatively easily, really quickly. And many other cultures continued to enjoy the ramifications of these policies. And a lot of immigrants that have had huge seismic impacts on our society today among them. Notable example, Frederick Trump. I say Trump with an F, Trump. He was born in 1869 to 1918, emigrated from the state of Bavaria, Germany, Bavaria is Germany, to Seattle, Washington. A development called the Pinewood Plateau was the Trump family's first major real estate purchase after they emigrated from Bavaria. Fred tried to return to Bavaria later, but he was actually thrown out for dodging military service because he came to the United States when he was 16, right before he was eligible for compulsory service in Germany.
Oh, nice.
And returned only a few months after his 35th birthday, when he was too old to serve.
Nice.
And
That's clear.
the Bavarian government fucking noticed, and they were like, no, and they stripped him of his citizenship, but by then he had U.S. citizenship,
And
so he went back to the U.S.
This isn't the Trump family, is
No,
it?
it is.
It is?
They were originally named Drumpf, Drumpf, but they changed it to Trump or Trump, depending on who you ask, during the 30 Years' War.
I didn't know that. I didn't know that they came to Seattle first.
Yep, Frederick Trump. The very first real estate
news.
purchase of what would become the Trump real estate empire was done right here in Seattle, Washington.
Wow.
And he could only do that, and he got citizenship in about 4 years
That's
without really trying.
So much better than many, many Chinese people who've had to struggle through this.
Well, beyond that, it was just like it takes years and years and years and years if you ever get citizenship. Most people just squeak out a green card and then sit on the list for 20 years. So it's a huge deal when you get your citizenship. He got his U.S. citizenship in 1869, only 4 years after arrival. He died in the fucking 1918 Spanish flu pandemic.
Oh.
Fun fact. Yeah. So he and the Trump family have historically benefited from these policies, and that's why we wanted to highlight this, because everyone claiming that, like, we're invading, we can't assimilate people, these people don't belong here, they usually come from families who were among the immigrants who basically ran off the boats and were just handed citizenship certificates or whatever the hell I don't think they actually issue certificates. I haven't looked that far.
Sure.
The Chinese Exclusion Act was so a shocking surgical attack on the fundamental justice and the rule of law, in my opinion, backdropped by other races and nationalities just walking in. So it was a very rude and disgusting wake-up call for many people in the East.
It really is. It's I want to say blasphemous. But
it feels
disgusting.
wrong.
It feels wrong.
Yeah.
It's absolutely not justice.
Luckily, in the 1940s, even though the quotas remained at basically zero, the civil rights movement really benefited many races and cultures beyond black folks here in the United States.
Good. That's what we like to hear.
Because the blowback made it a lot harder for the federal government politically to push, the boot down on various other minorities' necks. So there were, know that this is a story for another time, but there were many, many side effects of Dr. Martin Luther King's work that were fantastic. And I think up next, we're going to be talking about Wong Kim Ark himself, because that was all context. We need to talk about the case that actually brought it all home, and we'll be right back right after these words from our sponsors. Hey guys, thanks for listening. First off, thanks to our sponsors, Hemmat Law, NordVPN, and Quimby Bar Prep. They're huge supporters of the show. If you want to support the show, go to gossipwithoutprejudice.com. Pledge as little as $5 keeps our lights on and keeps this show going. It would be a personal favor to me and Lindsay if you could show this show to someone who you care about or who would care about our work or the rule of law. We really love covering this. It's been a great passion project for us, but only about half of the people who listen to this show regularly are subscribed. Leave us a review, hit all the good buttons, spread the word. Thanks so much. And welcome back. We are now going over the story of Wong Kim Ark. Thank you for that quick interlude. We'll jump right into it here. In August of 1895, a young cook named Wong Kim Ark was about to disembark from the steamship Coptic after a long journey home to San Francisco from China when U.S. custom officials denied him re-entry.
Oh.
They didn't let him in. Mr. Wong had been born in San Francisco's Chinatown, one of the largest Chinese communities in the United States to this day. But also at that time, China and Seattle both have large Chinatown districts. We actually here our little Japan got a little bit bigger, but Chinatown in San Francisco, where my mother grew up, actually was like a foundational part of that community. Anyways, he was born in San Francisco, not far from the port where he was actually disembarking and being held.
So, did he have any visa? Did he have any paperwork?
Well, he didn't because he was born in the U.S. and he claimed he was a citizen. He had actually left the U.S. to visit China once before in 1809 on the steamship Gaelic. I like throwing in steamship trivia. He was granted admittance back into the United States when custom deemed him to be a U.S. citizen.
Great. Okay.
So he didn't.
So the first time it went flawlessly.
Yeah, first time it went flawlessly. He had grown up in San Francisco. He was American in every way that counted, but he had family back in China. He cared about China. His community was Chinese immigrants. He spoke Chinese at home. So he was going back to China to visit. And remember, these visits were quite ordeals because you had to be on a steamship. Like you couldn't take a flight.
Whew.
Yeah, exactly. You had to cross the Pacific.
Had to be on the Gaelic for a whole month.
And he came, hey, you remember the steamship. And so he came back to the United States and they didn't let him back in because they said he wasn't a citizen. When he returned to China, the second time, he didn't expect to be denied, and so he sued the federal government in recognition of his sovereignty as a U.S. citizen and to getting readmittance to the country. And his case made its way to the Supreme Court of the United States of America, and so Wong Kim Ark, the stage was set.
Wow. Do we know during this time, had he returned to China and he was fighting this case from China, or when?
Oh, he was in the United States.
Okay.
Yeah. My understanding is that he hired counsel, and I did not go into the procedural history, and you will see why in a minute. Because, folks, I have got like 5 paragraphs of text to read you, more like 10, depending on how you count them. The reason this is going to be such an ordeal is because legal opinions from any time before like 1970 are a nightmare. All right. But I have to read this to you because it's so crucial to understand both the historical context of what was going on then and how this impacts the Trump administration and society now. And the only way to do that is to read you quotes from Justice Horace Gray, the United States Supreme Court justice who led the majority opinion in Mr. Wong's case.
Well, I'd like to say that in advance. Thank you for digesting this for us.
This one, unlike other administrative orders we've read who have been quite short on this show, this one's really fucking long. So these 10 paragraphs that I'm going to go over in the next part of the show are the barest bones of the analysis that the court waxed eloquent. We will put the full opinion in the show notes, but traveler beware, because this is both long and the language is really fucking difficult to read. Like, just, it gives me a headache. The older the court opinion, the bigger an exercise in patience it is to understand and read it, which is why we don't write like this anymore. It's just too many heretofores.
Too tedious.
Yes. So I will read from you directly from the court's opinion. So
thank you.
We're going to start with laying the groundwork here. Quote, Wong's father and mother were persons of Chinese descent and subjects of the Emperor of China. Because remember,
Imperial.
Communist China had not risen yet, so this is all during Imperial China. The state was in decline, but it still existed. They were at the time of his birth domiciled residents of the United States, having previously established and are still enjoying a permanent domicile residence therein at San Francisco. See, that's shit like that I hate. Basically, his parents lived in San Francisco. He didn't need to make that sentence that long.
It's like twice as long as it needs to be.
Quote, They continued to reside and remain in the United States until 1890, when they departed for China, and during all the time of their residence in the United States, they were engaged in business and were never employed in any diplomatic or official capacity under the Emperor of China or the Chinese government. Wong Kim Ark, ever since his birth, has had but one residence, to wit, in California within the United States, and has there resided, claiming to be a citizen of the United States, and has never lost or changed that residence. It's going to keep going like this, or gained or acquired another residence, and neither he nor his parents acting for him have ever renounced his allegiance to the United States or did or committed any act or thing to exclude him therefrom. So now you see what I'm talking about. That paragraph was like 2 sentences, but basically, they've always lived in the United States.
Mm-hmm.
They've always intended to return and reside fully in the United States. They have business in the United States. They've never renounced their U.S. allegiance in any way.
They're not foreign agents.
That call out was like they're not diplomatic agents, which is something that'll come up here. They're not emissaries of a foreign government in their personal capacity. And that sets the stage for this discussion. Like, they're just people. He was born here. The family resides here. Never lived anywhere else.
Far too many words, but wonderfully, like, plainly stated. They're not dancing around the issues.
Yes.
He is from here, okay?
And here we go. This is the heart of the matter. Quote, "The question presented by the record is whether a child born in the United States of parents of Chinese descent, who at the time of his birth are subjects to the Emperor of China, but have a permanent domicile and residence in the United States, and are there carrying on business and are not employed in any diplomatic or official capacity in the Emperor of China, become at the time of his birth a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution." Yeah, so basically whether or not, if you're born to foreign citizens in the United States, are you a U.S. citizen? I don't know why he had to make it that long.
Yeah.
We're going to be seeing a lot of that in this opinion. So now's a good time to talk about the 14th Amendment. So the relevant part of the 14th Amendment, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
Okay, so that's really plain and simple.
Yeah.
So now I'm going, why the hell is there even a case about this?
There's a case about this because the Constitution nowhere defines what this means. Either exclusionary or inclusionary definition of what subject to the jurisdiction thereof. And it's the subject to the jurisdiction thereof that's where everybody's losing their mind, both back then and today.
Okay.
So the 14th Amendment, for a little bit of history, is basically an amendment surgically targeted to overturn the Supreme Court decision of Dred v. Scott. Dred v. Scott, what am I talking about? The Dred Scott case. It is a case that basically 7-2, let that sink in, 7 of 9 justices said black people are not citizens and cannot be citizens of this country.
Wow.
Yep. And so in the wake of post-war, because this is during the 1880s, so this is post-war Civil War Reconstruction, the federal government passed an amendment to the Constitution saying, if you're born here, you're U.S. citizens.
Thank goodness.
And that was targeted at the slaves, basically, and their children, because they had been born here but were not citizens of the South or anywhere else. And the Supreme Court got it really fucking wrong. And they were like, not just by a narrow majority, but by like 7-2. We should go over that case another time. They were like, black people cannot be citizens, which is bonkers.
Disgusting.
But the 14th Amendment specifically came in and said, nah.
Good.
Problem. Congress never defined what subject to the jurisdiction thereof meant. So I'm going to keep reading Horace Gray's majority opinion here.
Thank you, Horace.
And this is the part where we're getting into like 5 paragraphs. So stick with me.
I'll just be quiet.
We'll take breaks throughout. Yeah. Okay. Quote, "As appears upon the face of the amendment, as well as from the history of the times, this was not intended to impose any new restriction upon citizenship or to prevent any persons from becoming citizens of the fact of birth within the United States who would thereby have become citizens according to the law existing before its adoption." Basically, there's no restrictions. This was not intended as a restrictive amendment. TLDR. I continue. In its declaratory form and enabling and extending in effect, its main purpose doubtless was, as having been often recognized by this court, to establish the citizenship of free Negroes, quoting from the opinion, which has been denied in the opinion of delivery of Chief Justice Taney in Dred Scott v. Sanford. That's a call out to Dred Scott. And to put it beyond doubt that all blacks, as well as whites, born or naturalized within the jurisdiction of the United States are citizens of the United States. But the opening words, quote, "all persons born," are general, not to say universal, restricted only by place and jurisdiction and not by the color or race. So basically, the court here is like, hey, we have to recognize the intent here was to be broadly expansive. We have to recognize that we're refuting the prior Chief Justice Taney and Dred Scott v. Sanford, which is the Dred Scott decision, and to put it beyond all doubt that like racial elements are not relevant here.
Beautiful.
Which is good that the court recognizes this, because law and politics are intertwined, and they really want to make it clear that like, hey, the court has an eye on this prior context when making this decision now. We continue from the majority opinion. The real object of the 14th Amendment of the Constitution in qualifying the words, quote, all persons born in the United States by the addition, quote, and subject to the jurisdiction thereof would appear to have been to exclude by the fewest and fittest words, besides children members of the Indian tribe standing in a peculiar relation to the national government unknown to the common law, and two classes of cases, children born of alien enemies and hostile occupation and children of diplomatic representatives of a foreign state, both of which, as has already been shown by the law of England and by our own law from the time of the first settlement of the English colonies in America, have been recognized exceptions to the fundamental rule of citizenship by birth within the country. So what he's talking about here is what I have not included in this excerpt is that in order to reach this analysis, the court went on for like 20 pages about English common law. They were like, what is the foundations of common law recognized about citizenship and recognition back in England, because it was the only parallel we had.
Wow.
So they're talking here. What that meant was basically, hey, the common law has historically recognized everyone except alien enemies in like a hostile occupation, so like an invading literal army, and also foreign dignitaries. So, and that holds to this day. If you are like an ambassador or part of a diplomatic mission and you have a kid in the United States, doesn't count.
Huh.
Yeah.
Okay.
Because you're not in the United States. They don't have jurisdiction over you,
Yeah.
is the thinking. It's like,
That makes sense. That tracks.
Yeah, you're here on behalf of another government. We're not going to
Yeah.
recognize you as citizenship.
Okay. Thumbs up.
And then the courts also say, besides children of members of the Indian tribes. And that's because common law had no parallel. England does not have Indian reservations or treaty relationships with sovereign First Nation states. And so the court was like, that's not in common law, but like that's a little bit different here because this is a uniquely American thing. So there's no precedent back in English times.
So let's just put that in a little parenthesis.
Yeah. So, and that's true. First, this is an episode for another time, but First Nation tribal relationships, treaties between the federal government and Native American tribes, they are sovereign states. They have the limited jurisdiction. We'll get into that later. But they are considered foreign governments of a quasi nature. Now, they've kind of blended together because of the reality we're all living in the same territory. But
I've always been curious about that.
Yeah,
because there's a lot of tribal reservation land around here, and so it's
Indian law is a huge part of Washington's legal landscape. The University of Washington School of Law has a fantastic expert on it. We should bring them on.
Oh, cool.
All right. Anyways, off track. I continue. The principles upon which each of those exceptions rests were long ago distinctly stated by this court. By the Civil Rights Act of 1866, quote, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, were declared to be citizens of the United States in the light of the law as previously established and in the history of the times. It can hardly be doubted that the words of that act, quote, not subject to any foreign power, were not intended to exclude any children born in this country from the citizenship which they would theretofore have been their birthright, or, for instance, for the first time in our history, to deny the right of citizenship to native-born children of foreign white parents, not in the diplomatic service of their own country, nor in hostile occupation of part of our territory. Basically, the court's like, we're recognizing this. It would be highly unusual for us to suddenly say, to deny the right of citizenship to native-born children of foreign white parents, not in the diplomatic service, does not jive with the Civil Rights Act of 1866, which is the post-war Reconstruction, when a whole bunch of stuff to basically bring the South in line were passed by Congress. It continues, but I don't. There we go. Quote, but any possible doubt in this regard was removed when the negative words of the Civil Rights Act, quote, not subject to any foreign power, gave way in the 14th Amendment of the Constitution to the affirmative words, subject to the jurisdiction of the United States. So there was some conflicting language in that might have been entered into interpretation by Congress. But the 14th Amendment rules, and it has affirmative language, not exclusionary language, and the court is drawing attention to that. Quote, subject to the jurisdiction of the United States is an affirmative signal, right? It's not exclusionary. Unlike the Civil Rights Act, quote, not subject to any foreign power. That matters because subject to foreign power could mean citizenship.
Okay, sure.
But they didn't say that. They didn't say subject to a foreign power. They just meant subject to the jurisdiction of us.
Okay.
Which is much more expansive. So that's what the court is saying. It's like, this appears to be expansionary language, not narrowing. Okay. And that's what the court is designed to do, is they're designed to sort of, when they have no better guideposts, is to sort of interpret the will of Congress as the law was passed. So they're doing the historical analysis and comparative analysis they're supposed to as justices.
Right.
Quote, the foregoing consideration and authorities irresistibly led us to these conclusions. The 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children here born of resident aliens, with the exceptions or qualifications, as old as the rule itself, of children, born to foreign sovereigns or their ministries, or born on public ships, or of enemies within during a hostile occupation of part of our territory. So basically, the common law recognized, like, if you're an invading army, or if you're in maritime law, very few exceptions, or a foreign dignitary. Those old exceptions were recognized by English common law. We're recognizing them here, but everyone else, subject to our jurisdiction here in the United States.
Okay.
How are you feeling so far? Are you with me?
I'm a little, I think I'm mostly with you.
Yeah. Tell me what I need to clarify here, because that was a lot to throw you. We're about halfway through.
Okay. So I'm following that they're defining here who is born citizen and who isn't.
Yep.
I'm thinking my thoughts are getting convoluted by current understandings.
Yep.
I'm having a little trouble keeping the modern immigration, which I also know almost nothing about, and this separate, but I'm following along, and it's kind of silly. It's kind of silly.
Well, I mean, it's silly because you see courts trying to grapple with history when precedent does not answer. Because remember, this is post-work Reconstruction, right? It's a little bit in the past at this point. It's not the 1860s.
But it's a time of change.
It's a time of great change. And so the court is really trying to be like, what's been recognized by precedent here? The intent of Congress, what's the intent of Congress passing all these civil rights laws? And then also the 14th Amendment. That all seems to be coming together pretty interestingly. I think it's well summarized here. Quote, the amendment, in clear words and in manifest intent, and that's what the courts were looking for with all that comparative analysis that I summarized, is they were looking for intent.
Sure,
right?
yes.
Includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. Every citizen or subject of another country, while domiciled here, is within the allegiance and the protection and consequently subject to the jurisdiction of the United States. That's the key interest.
Beautiful.
Is there like, what does subject to the jurisdiction of? It means within the allegiance and the protection of. And the protection of is you're here in the country physically, pretty much. Narrow exceptions apply. That's jurisdiction. Therefore, you're in the club if you have a kid.
Okay.
Yeah.
Beautiful. So what they're stating here explicitly is that Mr. Wong should be allowed back in the country, right? That's what they're all working back towards with this.
They continue. Mr. Wong's allegiance to the United States is direct and immediate, although but local and temporary. It can hardly be denied that an alien is completely subject to the political jurisdiction of the country in which he resides. Seeing that, as said by Mr. Webster, then Secretary of State, in his report to the President on Thrasher's case in 1851, and since repeated by this court, quote, it is well known that, by the public law, an alien or a stranger born for so long a time as he continues within the dominions of a foreign government owes obedience to the laws of that government and may be punished for treason or other crimes as native-born subject might be, unless his case is varied by some treaty stipulations. Basically, he's saying, hey, the federal government has recognized that if you're here, you're subject to our protection and our laws, right? And so it would be very strange. I think, reading between the lines, the court is saying it would be very fucking strange to say, so we can punish you for crimes, so you're clearly within our jurisdiction, but now you're somehow not within our jurisdiction when it comes to giving you citizenship. And I think the court is saying you can't have it both ways, right? That's respected both here in the United States and virtually everywhere else on the planet. You're not immune. If you go to a country, you're subject to its laws, no matter how draconian.
Yeah.
That's the risk you take.
Works out for me.
Yeah. Quote, whatever considerations in the absence of a controlling provision of the Constitution might influence the legislative or executive branch of the government to decline to admit a person to the Chinese race to the status of citizens of the United States, There are none that constrain or permit the judiciary to refuse to give full effect to the preparatory and explicit language of the 14th Amendment. So that was some very confusing language that I hated reading. But it basically means courts, it's in the Constitution, courts don't make policy, right? They just, at their purest form, they call balls and strikes, right? They just say, this is what Congress wrote. We rule on this, even if we think it's a bad idea. When judges are doing their job, they just rule on the merits of the facts before them in the intent of the Congress that passed the law at the time, not the intent of the Congress today. That's the key difference, right? That's why they're always looking for intent from a backwards perspective. And and while the court recognizes here, like, quote, might influence the legislative or the executive branch of government to decline to admit persons to the Chinese race or the status of the citizens of the United States, basically you could say you can choose to like naturalize citizens later by executive or congressional action as may be applicable. But the Constitution says this, the judicial branch can't ignore the Constitution, and he was born here. Like his parents weren't born here, so that's a separate discussion is what the court's calling out, but this is here and now. And the 14th Amendment, which declares and ordains all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens.
Beautiful.
That's all that means.
There it is.
Yeah.
And this is all still Mr. Horace Gray?
This is where we haven't even gotten to the dissent yet by Chief Justice Melville.
Wow.
Yeah.
Goodness.
We're almost done, though. This is the fun stuff.
Okay.
Yeah, the acts of Congress known as the Chinese Exclusion Act, what a banger, the earliest of which was passed some 14 years after the adoption of the constitutional amendment, cannot control its meaning or impair its effect, but must be construed and executed in subordination of its provisions. Basically, Constitution trumps laws. Constitution trumps laws. Okay. And just because you passed, this law after the constitutional amendment was put in place, you got to amend the Constitution to take that out.
Got it.
Quote, and the right of the United States as exercised by, under those acts, to exclude or expel from the country persons of Chinese race born in China and continuing to be subjects of the Emperor of China, though having acquired a commercial domicile in the United States, has been upheld by this court for reasons applicable to all aliens alike and inapplicable to citizens of whatever race or color.
There it is.
Yeah.
Beautiful.
And then last paragraph, stay with me here, people.
Okay, one more.
Upon the facts agreed in this case, the American citizenship, which Mr. Wong acquired by birth in the United States, has not been lost or taken away by anything happening since his birth. The evident intention and the necessary effect of the submission of this case to the decision of the court upon the facts agreed by the parties were to present for determination the single question stated at the beginning of this opinion, namely whether a child born in the United States or parents of Chinese descent who at the time of his birth, blah, 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 permanent domicile and were carrying on business, blah, 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 blah. For these reasons stated above, this court is of the opinion that the question must be answered in the affirmative.
That yes, he is a citizen of
He is a citizen.
country.
He was born here. He was domiciled when he was born.
Yup.
Subject to the jurisdiction. Let him in.
As convoluted as this is said, plain and simple, folks.
Yes. So the good news is that was almost all the paragraphs. But for the dissent written by Chief Justice Melville W. Fuller.
So this is another Supreme Court judge, right?
The Chief Justice.
The chief of the Supreme Court.
Chief racist, actually. Chief Supreme racist at this time in the enlightened time of the 1880s. Or I think it was just like 1890 by this point.
Oh, Melville.
But he basically takes the opposite position, subject to the jurisdiction thereof. And the reason I'm reading from you the dissenting opinion is because the Trump administration is hanging their hat on this dissent and the philosophy it entails.
Ooh,
so
don't like this at all.
Chief Justice Melville dissents from the majority opinion, which doesn't matter for the outcome, but is important to frame. Quote, by the 13th Amendment of the Constitution, slavery was prohibited. The main object of the opening sentence of the 14th Amendment was to settle the question upon which there had been a difference of opinion throughout the country and in this court as the citizenship of free Negroes. In Scott v. Sanford, that's the Dred Scott case, and to put it beyond all doubt that all persons, white or black, and whether formerly slaves or not, born or naturalized in the United States, and owing no allegiance to any alien power should be citizens of the United States and of the state in which they reside. So basically, even the Chief Justice Melville is like, I acknowledge the 13th Amendment banned slavery, except for in cases of incarceration as a punishment to a crime. So slavery is actually still legal in the U.S. It's why prisons run. Episode for another time. But it banned what would be known as chattel slavery, where men not punished by a crime could just be purchased.
Never thought I'd hear you say on this show, slavery is legal in the U.S.
It still is. By constitutional amendment, slavery is still legal in the United States. Anyways. But even this dissenting opinion calls out that, like, hey, 13th Amendment was to do this. 14th Amendment was to say they are now all citizens. So it basically calls out the same thing that the majority opinion called out, saying, like, this was the purpose of this amendment. This is
the question that we are asking and what we're looking at. Okay.
But Chief Justice Melville differs in the execution in the second paragraph.
Okay.
This section contemplates two sources of citizenship and two sources only: birth and naturalization. The persons declared to be citizens are all, quote, persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some sort of respect or degree to the jurisdiction in the United States, but completely subject to their political jurisdiction and owing them a direct and immediate allegiance.
Didn't follow that one.
So basically, the majority interpreted subject to the jurisdiction thereof to mean, like, you're under our protection, you're subject to our laws, jurisdiction, case closed, TLDR. But the Chief Justice is interpreting this to mean you share no other allegiance, citizenship. So that's what they're going to go into. The evident meaning of these last words, subject to the jurisdiction of, is not merely in some respect or degree to the jurisdiction of the United States. Basically, being in our borders, subject to our laws, is not enough, but completely subject to the United States' jurisdiction, like a citizen, an exclusive citizen, or exclusively owing your direct life to the United States. It's a much higher standard. And the words relate to the time of birth in one case as they do in the time of naturalization in the other. Persons thus subject to the jurisdiction of the United States at the time of birth cannot become so afterwards except by being naturalized either individually or as proceeding under the Naturalization Acts or collectively as the force of a treaty by which foreign territory is acquired.
I'm not following Melville here. I'm following the words, but I'm not understanding what he's trying to get at.
So basically, I'll read again. And the words relate to the time of birth in the one case, as they do in the time of naturalization in the other. So basically, all persons born or naturalized. So he's interpreting that to be exclusionary. So born or naturalized, that's it.
That's all you got.
That's all you got. And subject to the jurisdiction thereof. The modifier of jurisdiction means, like, you are completely subject to the political jurisdiction, meaning you don't have other citizenship.
Okay.
Is what this court means. Because they're arguing that, like, well, this goes on to make a very long-winded point that I won't read you, but what the Chief Justice goes on to say is that, like, the reason we made a separate example of the freed slaves in the United States is because they were never subject to any other jurisdiction.
Okay.
They owed their complete political allegiance to the United States federal government, and therefore 14th Amendment applies to them and their children because they were born here, they were never citizens of anywhere else, and that's the distinction. Here, Wong's family, and arguably Wong himself, were Chinese citizens. And so you're therefore not completely, the court read the word complete political jurisdiction, like complete into the language, which I would argue is a very weak interpretation.
Yeah.
Yeah.
Based on the fact that I did not even follow what he was trying to say, I agree that this is very weak.
Yeah. Yeah. So the quote from the Justice Melville that operates is, quote, but completely subject to the political jurisdiction. So the word completely is not in the 14th Amendment. It just says subject to. And I think that's where the Chief Justice goes wrong. It's like it's a higher standard that's not evident in the text.
Yeah, he basically added a word. He added a requirement.
Yeah. And even then, it wouldn't be clear if completely meant citizenship. That's still not in the language.
Right. These aren't... Nope, don't like this, folks.
Chief racist.
Seriously.
Except by being naturalized, either individually, as by proceedings under the Naturalization Acts, or collectively as by the force of a treaty by which foreign territory is acquired. Basically, like the Louisiana Purchase.
Yeah.
All the people in the Louisiana Purchase then became U.S. citizens or eligible for it.
By the treaty.
By the acquisition of the land, and therefore completely political.
Got it.
I am struggling to explain this because I think it's a very weak argument. The majority of the court said, nope, subject to the jurisdiction thereof. It's been long recognized by a variety of common law standards which the U.S. is based on, that barring some narrow exceptions, you're here in our states, you're subject to our laws, and therefore, if you are born here, you are a citizen. To be completely, and then here's the finishing sentence. I haven't read you yet. Quote,
Okay.
to be, quote, completely subject to the political jurisdiction of the United States is to be in no respect or degree subject to the political jurisdiction of any other government.
Okay, so he's saying if you are a citizen or a national of any other country, you cannot be a U.S. citizen.
So the Chief Justice read the word completely subject rather than just subject, and then said, well, completely subject means you can't be politically, tied to any other country, and that means citizenship.
Nope, I don't like it, folks.
Yeah.
I don't like it.
So that's what the dissenting opinion staked its life on, and it lost, which is good.
Yay.
So here's the splitting of hairs with slaves is why I wanted to read this next section. So it's not related to the overall discussion of the dissenting opinion, but I think it's poignant to see why the court's sort of doing mental gymnastics to get over this.
Okay.
Quote, in providing that persons born or naturalized this is the dissenting opinion by the Chief Justice, born or naturalized in the United States and subject to the jurisdiction thereof as citizens, the 14th Amendment undoubtedly had particular reference to securing citizenship to the members of the colored race, whose servile status had been obliterated by the 13th Amendment. I like that, obliterated by the 13th Amendment, and who had been born in the United States, but were not and never had been subject to any foreign power. So that's basically how the court is like running backflips to be like, well, yeah, it applies, but it only applies to like the freed slaves because actually they don't owe political allegiance to anyone else because they were, it just doesn't quite jive.
No, it really does not jive.
But the court basically tried to split hairs between tried to like take this clear intent of the 13th and 14th Amendment recognized by the wider court and society writ large and say, my analysis counts, but it doesn't count for them because actually they're not citizens of anywhere else. So therefore, they're citizens now.
Nope, don't like this one bit. What about all of the folks who were brought against their will to this country to be slaves, who carried pieces of their culture with them and who like associate with the original place that their ancestors or even their parents came from? Like that's same thing.
Quote, they were not aliens. And, which flies right in the face of the Dred Scott decision.
Yeah.
But, quote, they were not aliens, and even if they could be so regarded, this operated as a collective naturalization, and their political status would not be affected by any change in the laws for the naturalization of individuals. So basically, the court's saying this falls under that basically treating the 13th Amendment as if it were like some sort of like land acquisition by citizenship, which is the only parallel I could draw from the rest of the dissenting opinion, which feels kind of icky. Basically saying, well, this counts as a collective naturalization of these people who have no other citizenship. Therefore, the 14th Amendment applies to them, but it applies to no one else. And that's the full opinion. We'll throw the full opinion. It is a doozy of a read. And if shout out to there was one citation in the majority opinion that I absolutely fucking loved. Shout out to Lord Chief Justice Cockburn.
Wow.
Yeah, cited by the majority opinion in the historical analysis of English common law in the matter of Udney v. Udney, 1869. So yeah, Lord Chief Justice Cockburn was one of the sources that I absolutely giggled at while reading this. So English Lord.
Thanks.
It's an English Lord. Yeah, exactly.
Thanks for your historical precedent there, Lord Cockburn.
And then we're going to jump right into the Trump administration's attack on Wong Kim Ark as precedent.
Okay, so we've got all the context now of the case. Now we're going to dive into the modern
stuff.
Okay,
yeah, so,
beautiful.
So we're finishing this off with a modern break. But we'll be right back after these words from our sponsors and a quick CTA. I think the sponsor will be us because we're going to be putting in a CTA telling you guys to subscribe. So watch this little thing. When we get back, we're going to be talking about the Trump administration's attack on birthright citizenship in the modern context, going back after 127 years or so of settled precedent. So we'll be right back after these words.
Thanks for listening to Gossip Without Prejudice. Please take a moment to like and share and subscribe to the show. If you'd send us to a friend, we would greatly appreciate it. And an extra special thanks to our sponsors. That's Hemmat Law, Quimby Bar Prep, and NordVPN. Thanks for listening.
Okay, welcome back. Sorry for that quick interlude. We are jumping into the Trump administration's attack on birthright citizenship. So on January 20th, 2025, his first day back in office, President Trump signed an executive order declaring that the government would stop treating U.S.-born children of parents who are undocumented or are in the country temporarily as U.S. citizens. So basically, it ends birthright citizenship. That the court says everybody's subject to their jurisdiction thereof. And the Trump administration basically takes the exact same tact as the dissenting Chief Justice by saying they're not subject to our jurisdiction. So I'll read, we'll put the executive order in the show notes, but I'll read from here. Quote, Section 1, purpose. The privilege of the United States citizenship is a priceless and profound gift. Propaganda. The 14th Amendment states, all persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott v. Sanford, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. So even the Trump administration calls out the historical context behind the 13th and 14th Amendment and the repudiation of Dred Scott v. Sanford, 60 U.S. 19393, 1857. Remember, Dred Scott went by a vote of 7-2.
That's not okay. It's really, it twists my brain in an uncomfortable way to have these two things in this one paragraph. We have the rightly repudiated the shameful decision of Dred Scott versus Sanford. But then also, this privilege of United States citizenship is a priceless and profound gift.
Well, it is. It's one of the most powerful citizenships in the country. In the country. It's the most powerful citizenship in the country. It's the only one. On planet Earth, until recently, Brand America was very powerful. All the movies and music was made here. So they're actually correct. Brand America is pretty toxic right now, but I digress. I'll continue reading the order. Okay. Quote, but the 14th Amendment has never been interpreted to extend citizenship universally to everyone born in the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not, quote, subject to the jurisdiction thereof. So you see what they're teeing up here? Mm-hmm. They're saying they're technically correct. It is limited by subject to the jurisdiction thereof, but here's where it takes, here's where it takes a turn.
Okay.
Here we go. Quote, among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of the United States citizenship does not automatically extend to persons born in the United States. 1, when the person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. There we go. 2, when the person's mother's presence in the United States at the time of said person's birth was lawful but temporary, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. Basically, they say, nuh-uh. They basically just ignore the Supreme Court precedent. The president's order, one of several issued in the first 3 hours of administration to curtail immigration, basically just declared children born in the United States to undocumented immigrants after February 19th would no longer be treated as citizens. The order would also extend to babies born to mothers who are in the country legally but temporary, such as tourist visas or temporary workers, if the father is not a citizen.
Really, really hate this.
Yeah, so, this is a common tactic where they dress it up in legalese.
Yeah, for sure.
And they say, and they split hairs where, the 14th Amendment has always excluded from birthright citizenship people who are born in the United States but not subject to the jurisdiction thereof. That's correct. But the interpretation of what's subject to the jurisdiction thereof is everyone. Virtually everyone. But that's not apparent from this order. If you read this order, it would seem like, oh, amazing. Look at that. They sound really fancy and therefore they must be right. But it basically, I wish I had a more cogent analysis than this. There's no citation. There's
really?
They didn't cite to anything. They just said it, right? And that's very plain in legal language. That's basically just not how this works. And I wish there was more complicated or nuanced way for me to say that. But there's no citation here. The Trump administration just declared it.
Wow.
And Congress has never changed the Constitution. And as long as the Constitution has never been changed in respect to the 14th and 13th Amendment, thank God, hopefully the 13th Amendment will never be. Law of the land stands. Yeah. And the courts have never weighed in to substantially change Mr. Wong's case. So it has been as settled law as can be found in this country, over a century of settled law. 127 years as of the time of this recording.
Wow.
And so the Trump administration does not have executive power to basically just rule. They can order the executive branch organizations to recognize XYZ policy, but if XYZ policy is unconstitutional, it will be halted by the courts. And so I so wish that I could say something other than that's not how this works, but that's not how this works. I've talked to some law professors that I used to talk to. I'm like, how can I explain this in a way that doesn't make me just sound like a pundit? There really isn't one at this time because the court went out of its way to say every person subject to the laws of the United States, it's not respective of their parent's status. It's like, is the child subject to our jurisdiction at the time of its birth? If yes, end of analysis. Yeah. What are your thoughts?
I strongly believe that it should just end there, and it should be that simple. I'm thinking about all of the folks whose like their family's plans have relied on them having children and being born as citizens in this country. And then all of a sudden, boom, that's swept out from under them. And now in a potential situation where maybe their goal is to create a life with more options and more freedom for themselves and their families, all of a sudden, boom, no, you've lost that. That's nope,
so,
I do not like this one bit,
So
folks.
the courts have stepped in to stop Trump's order.
Okay, so that was going to be my next question.
No less than 3 district court judges, federal district court judges, have entered nationwide injunctions.
Yay!
The first one, Judge John Cohener, in early February of 2025, he called citizenship a fundamental constitutional right, entered the very first injunction against Trump, halting the order in its tracks, so it's not being enforced right now.
Good.
He is in Seattle.
Oh, hey.
Yeah. He's also Judge John Cohener, nasty liberal appointed by Ronald Reagan.
Ooh.
Those activist Ronald Reagan judges fighting for the liberals. A federal appeals court in San Francisco then declined to remove the Cohener's injunction.
Good.
So Ninth Circuit says we're not going to step in.
We agree.
And to the individual plaintiffs named in the Seattle suit was brought by the Washington State Attorney General's office. So Washington State Attorney General's office played a pivotal role in opposing the first 2016 Trump administration, and they're doing it again. It's no longer Bob Ferguson, who was our prior Attorney General at the first Trump administration. Now we're governor. So the entire Washington State federal government I'm very proud of because they're trying to step in to save what's left of the Constitution, and they're quite effective at it. In Maryland, U.S. District Judge Deborah Boardman barred the government from enforcing the order there as well in a lawsuit brought by immigrants' rights groups and several pregnant women. Boardman stressed that, quote, no court in the country has ever endorsed the president's interpretation.
Beautiful.
And it's just not how it works. Like, I wish I could lend some more credibility to our rebuttal than that. But a federal appeals court in Richmond, Virginia also declined to pause part of Boardman's ruling. One judge dissented from that decision, calling the government's request a modest motion.
Disagree.
Appeals courts are 3-judge panels, generally speaking. So as long as 2 agree, majority opinion doesn't matter.
Cool.
And in Massachusetts, U.S. District Judge Leo Sorkin granted a request from 18 states, the District of Columbia, and San Francisco to put Trump's order on hold nationwide. So that's the big lawsuit, is that 18 states got together with D.C. and San Francisco, and they're in Massachusetts. Washington State filed it on their own.
Okay.
Washington State ran ahead of everyone else and filed on their own. And the judge explained that allowing the Trump administration to enforce the order in some parts of the country, but not in others, would be, quote, inadequate because, for example, pregnant women living in one state would cross state lines to give birth in another state.
Yeah, it simply couldn't work that way.
Yeah, so the courts, for practical reasons, not only is that like not how this works, but the court, for practical reasons, cannot limit their injunction to only apply to like certain states, because then you'll just travel out of that state, out of that circuit, and just go to the other circuit to have the kid, and then there's a citizen? I don't know. So,
mess.
Yeah, so basically everyone being born is still a citizen.
Good.
Until something else happens. A federal appeals court, also in Boston, rejected the government's request to partially pause Sorkin's ruling.
Okay.
So 3 different federal district judges have put brakes on this thing. How you feeling?
I'm feeling very glad. I'm feeling like I want to celebrate the the rule of law being followed above all else. That's what I like to see here, instead of xenophobia and fear and blocking people out. And
a good way to put it is the Trump administration, in their own twisted way, does recognize that the American dream is in decline. But the fundamental solution of the Trump administration, or just Republicans more generally, just specifically in the last couple of years, has been the solution to that increasing scarcity is more scarcity. Like, if we don't have enough, that means fewer people can come here, right? Is to just in various ways restrict even more. And on one hand, that's a human impulse that I understand. On the other, I think it's taking us in the wrong direction in the long run.
Yeah.
Anyways, so far the Supreme Court has declined to stay or narrow the injunctions.
Okay.
Note, I predict that this may be because doing so would sow confusion on who the policy change would apply to. So it may not be because because the Supreme Court is friendly to the plaintiffs. It may be because, just for practical reasons, should Trump succeed on the merits, it would just be really fucking confusing to halt a nationwide injunction on who was the citizen. Yeah. So the Supreme Court will hear oral arguments on May 15th on the federal government's request to be allowed to implement the President Donald Trump's executive order.
Wow.
Yeah.
The pace at which the federal government has been losing top quality employees makes me wonder if we're going to get top quality arguments on May 15th. But
we'll
I
see.
Doubt it. What brain drain?
Well, what's interesting is that the Trump administration's Supreme Court filings, I've reviewed them. They have spent far more time not talking about birthright citizenship, but for the power of lower court judges to issue nationwide injunctions stopping them.
Oh, that's not what
as in
about.
This case, as in this case, they're focusing more on the fact that nationwide injunctions can stop their progress than they are on the substance of the birthright citizenship. But that's probably because some of the court's justices have often complained about such nationwide rulings, and rather than deal with the birthright citizenship question on the merits, where the administration faces a significant uphill battle for various reasons, it may be easier to just take the shot on the birthright issue, but get their nationwide injunction power diminished. That would be my guess, is what this is really in it for them. I mean, the birthright citizenship juices up their base and makes it look like they're doing stuff, promises on immigration, whatever. But I think the real prize here would be they're here to get injunctions narrowed for the power of district courts to stop them.
But shouldn't the court have to come in and say, no, this is not the venue to decide abilities on injunction?
Well, it is. It's the Supreme Court.
I guess they just get
federal injunctions from district courts are federal courts that are overseen by the federal Supreme Court. So this actually is the place to talk about. I mean, my opinion is that the court is very unlikely to curtail its own power in such a direct way. But then again, my opinion was Chevron deference was here to stay, which was 50 years of admin law that they threw out a couple of months ago. We episode on that coming later. So stranger things have happened. My prediction, if not objected out, I think my strong prediction is that this will be rejected outright. I'm hoping. But if not rejected outright, I think the Supreme Court will take this opportunity to focus on the injunction question rather than the merits of the birthright citizenship. Because Samuel Alito, Clarence Thomas, and John Roberts at various times throughout their writings have at times complained about federal jurisdiction getting judicial action getting in the way of executive branch power. They are very much fans of strong executive power. For example, when they gave Trump immunity and the Office of the Presidency immunity from laws and prosecution for actions taken in his official capacity. So, my prediction is that if not rejected outright, the court will spend most of the time discussing this injunction question. Only 3 of the justices have to take up a vote to take up a case to give it cert.
I think that'll happen here.
Yeah, and to be fair, just because the court has agreed to take up a matter doesn't mean they like it. They may hate it, and they all agreed to take it on to put the matter to rest. It's hard to say. I think it's really, really difficult to predict Supreme Court actions because the Supreme Court thrives on a vacuum of information. That's why they're so highly respected, because they don't give speeches like politicians.
Right. Yeah, they interpret.
Yeah.
That's it.
They interpret and they rely on the prestige and mystique of the judicial branch, which is really unique.
That's for sure. There's nothing like that mystery that they've got.
And so we're coming up, 20 days from now, we'll have oral arguments. Might do an update on that, but then the opinion may come sometime later.
Wow. Okay.
Yeah.
I'm definitely going to be keeping a finger on this one, folks. Let us know what you think. I would love to hear your thoughts on whether we missed anything, but I don't know. I think you did a fantastic job breaking this all down for
Thank
us.
you. This was a really long one. This is really important. Like the both the birthright citizenship thing, but
And
also
the
injunction. Yeah, the power of
huge
district
deals.
courts to issue injunctions has basically been fundamental of how the judiciary works. So we want to do a really big deep dive. I hope you guys appreciated it, but we so appreciate you guys listening.
Oh, yes. Thank you so much for joining us, folks.